हेलो एवरीवन। आप लोग रेगुलर प्रैक्टिस कर रहे हैं जो कि बहुत अच्छी बात है। लेकिन एक छोटी सी चीज़ जो आप सभी कर सकते हैं, वीडियो को लाइक करें, कमेंट करें और सबसे ज़रूरी इस वीडियो को शेयर करें। शॉर्ट हैंड एक स्पेशल स्किल है और हम सब मिलकर एक दूसरे की मदद कर सकते हैं। आप जितना शेयर करेंगे उतने ही ज़्यादा स्टूडेंट्स को इसका फ़ायदा मिलेगा। जितने लोग जुड़ेंगे उतना ही हमारी शॉर्ट हैंड कम्युनिटी स्ट्रांग होगी। अगर आप नए हैं तो चैनल को सब्सक्राइब करना ना भूलें और बेल आइकन दबा दें ताकि आपको हर नए डिक्टेशन का नोटिफिकेशन मिले। आपका एक लाइक और शेयर मेरे लिए मोटिवेशन है और नए स्टूडेंट्स के लिए एक बड़ा सपोर्ट। चलिए बिना टाइम वेस्ट किए आज का लीगल डिक्टेशन शुरू करते हैं। अपना नोटबुक और पेन तैयार रखें और स्पीड मेंटेन करने की कोशिश करें। गेट रेडी, स्टार्ट। Learned counsel for the appellants sought and granted time to bring rules to indicate possession of the required qualification at the time of entry into service. The rules brought by the counsel for the appellants are the Uttar Pradesh Local Bodies Directorate Ministerial Services Rules 1992, in short Rules of 1992, and Group D Employees Service UP Rules 1985, in short Rules of 1985. In both the rules, reference of the post of tubewell operator, pump driver does not exist. Learned counsel for the petitioners appellants emphasis that rules of 1985 pertains to all the posts in group D, but it has not shown that the post of tube well operator, pump driver and also falls in group D, and otherwise the rules of 1992 referred by the appellants has no application to the aforesaid post, rather for different posts. In absence of possession of required qualification at the time of initial appointment, the regularization could not have been sought even pursuant to the rules of 2016. Though the engagement of the appellants is of the year 2000/2001, but in absence of the required qualification, we find no reason to cause interference in the impugned order passed by the respondent so as the judgment assailed by the appellant. The appeal thus fails and is dismissed. We find no merit or justification for condonation of delay. Delay cannot be condoned on the ground that the petitioner could know about dismissal of the writ petition when now all the informations are available on internet and one can access to find out date of the writ petition or its status, and for that one is not required to contact the advocate to obtain the information in pending writ petition. Thus, we do not find justification in condonation of delay, hence, the application is also dismissed. Hindu Marriage Act 1955, Section 24, Maintenance Grant of Interim Bail, Maintenance Matrimonial Case filed by appellant against respondent for declaration of their marriage as null and void ab initio, interim maintenance application by respondent stating that appellant has left her in destitution, impugned order directing appellant to pay rupees 5,000 per month as interim maintenance after adjusting any other sum received by her as maintenance marriage of the parties solemnized as per Hindu rites and rituals, assertion of the appellant that respondent concealed fact that she was earlier married with some other person after converting herself as Muslim and practiced Muslim religion test for determination of maintenance in matrimonial disputes depends on financial status of the respondent. Maintenance amount has to be sufficient to enable the wife to maintain herself with reasonable comfort. No infirmity or illegality in the order under challenged. First appeal dismissed. Mahesh Chandra Tripathi and Sanjay Kumar Pachauri JJ heard learned counsel for the appellant. Cause shows in the affidavit accompanying the delay condonation application is sufficient. The application is allowed. Office is directed to accord regular number to the appeal. Present appeal has been preferred, assailing the validity of the order dated 28 to 2020 passed by Additional Principal Judge, Family Court Number 2, Agra on the interim maintenance application 9GA under Section 24 of the Hindu Marriage Act 1955, filed in case number 172 of 2017, Sunil Sharma versus Srimati Gunjan Kumari, by which the opposite party appellant herein was directed to pay rupees 5,000 per month as interim maintenance on 10th of each month, with further direction that if opposite party is being given maintenance in any other proceeding, the same would be adjusted in this entry maintenance. Brief facts giving rise to present appeal is that the marriage of the appellant husband was solemnized with respondent wife as per Hindu rites and rituals on 21/11/2015 at Arya Samaj Temple, Raja Ki Mandi, Agra. It is alleged that after the marriage the appellant came to know that before the marriage the respondent had converted herself and practiced Muslim religion and was known as Sitara Begum. She married on 10th for 2013 with one Azimuddin Kunal Samir, son of Sri Samim Ahmad, resident of Rajaupur, PS Rajaupur district, JP Nagar, and out of the said wedlock a son was also born, namely Rian Aryan. Later the she separated from the said wedlock with compromise, and concealing this fact, she has remarried with the appellant when the said fact of her being non Hindu was revealed. She herself left the house of appellant, and with the collusion of her parental members, she filed a case number 329 of 2017, Srimati Gunjan Sharma and others versus Sunil Sharma and others under the provisions of Protection of Women from Domestic Violence Act 2005, DV Act, in which the Additional Chief Judicial Magistrate Court Number 7 Agra has passed an order on 21/8/2018 directing the appellant to pay a sum of rupees 3,000 per month to the respondent and also pay a sum of rupees 100 to the child of respondent, namely Aryan Sharma. It is also contended that as the respondent did not change her religion, Her marriage with appellant is null and void. The additional principal judge, family court number 2, has not considered the factual aspect of the matter and passed the order impugned. Stop.